which has been in the pipeline for many years now. I'd like to get your opinion on why you think the passing of such an act has taken so long, what the biggest hurdles are, and do you think it will be passed in 2011?
Mm-hmm. Okay, well, good question. Well, yeah, why has patent reform taken so long? The short answer is it's complicated, to paraphrase from a recent movie title, I think. It's complicated. There are many interests at stake. We have a unitary patent system here in the U.S., which means that it has to serve the interests, it has to serve the needs of those same many interests. There's a large community of innovators that's highly dependent on the patent system and has a strong and high stake in ensuring that any changes produce a net benefit, not a net, not a net detraction in the value of the services that we provide and the value of the intellectual property system. The kinds of changes we're talking about are very, very substantial. So you put all of those things together and you unquestionably get a situation in which it takes time in order to reach agreement, and a lot of refinement is needed, a lot of listening is needed. Again, as I'm fond of saying, we should celebrate the fact that our system moves slowly in this regard. That's called democracy, and we like that a lot. So, is it moving slowly? Yes. Is it okay? I think yes, because it's so hard and it's so important that we get it right. Now, what are the prospects for success in the near term, like 2011? I think they're actually pretty good. A lot of progress has been made. Many, I would say even most of the major hurdles have been resolved to getting patent reform done. There are many issues that drew sharp disagreements that have now been resolved, and there's agreement on them. We've been benefited by the fact that the U.S. court system, including the Court of Appeals for the Federal Circuit and the Supreme Court, have done a really good job at themselves addressing issues that could be addressed through the court system, and thereby taking hard problems off the table and removing some of the challenges from the legislative domain. So we're continuing here in the administration and at the USPTO to assist Congress. Our job is to provide technical assistance, and we're doing that very actively. Our administration is in favor of moving forward with patent reform, and I personally remain optimistic that we're getting closer, and it certainly can be done.
Would you say it's been challenging for you to working with Congress? What have been some of the challenges in getting the administration's viewpoints across to Congress from your point of view?
Well, I don't know if I'd use the word challenging. What I would say is that it is again complicated because there's so many interests at stake. It is necessary for us to be able to communicate in the patent system and the trademark system about highly technical, complicated legal issues in a way that makes sense to what I call real people. People like members of Congress who have, Americans that they're trying to help get jobs and that they're trying to help to put new products and services in the marketplace. And it's our job to take a technical, complex set of laws and translate them into English, if you will, into a language that decision makers can understand. And that's a hard problem. And so when you factor all of that in, it's understandable that that there would be challenges and lots of iteration and ongoing discussions in order to help Congress come to good legislation here.
Are there any specific frustrations that you could share?
Again, this is a big enterprise, the U.S. government, and so I think my philosophy anyway is that to be successful as a leader, one must understand, accept, and in fact celebrate that things take time. So that's why I don't really feel frustrated about anything. I do feel that we've made progress. We continue to be challenged by some details that we've got to work our way through in this legislation. We continue to make progress with Congress in that regard, and so to me this is all normal. This is making a democracy work. It's okay.
Okay, thank you. It's one of the areas of specific concerns to our readers, who are largely lawyers. It's the recent Bilski decision. Mm-hmm. I wanted to quickly just get your opinion on that, just as brief as you like. What you thought about the Supreme Court's decisions and whether you feel the law needs further clarification. Mm-hmm. And that kind of.
Well, this is, of course, a very hard area of the law, so-called statutory subject matter, and particularly the patenting of methods of doing business or inventions that involve methods of doing business. I think the Supreme Court gave us some very helpful guidance. Supreme Court, as patent lawyers and engineers, I often say that we want rules. We love, engineers. I'm an engineer. I love rules. I love a formula. I love, a recipe that I can follow. And the Supreme Court gave us some really good guidance in this particular case and said, look, there isn't going to be a specific recipe here. We're going to have to have some principles and guide by principles. And so it's our job now in the USPTO to help now to fill in details underneath those principles. And that's what we're doing. So we put out a set of guidelines for our examiners to use very, very quickly after the Bilski decision. We immediately went into a public comment period, and we've gotten a lot of great comments from the public, including from practitioners overseas, including in Europe, who had very valuable